The Cultural Party of Kenya has won closely contested general elections on the platform of repealing colonial laws that criminalize cultural practices. In his victory speech, the party leader declares, as promised during the campaign, we shall discriminalize the use of traditional brews. We shall also discriminalize the use of bang. We shall discriminalize child marriage since this was part of our culture. On the other hand, we shall criminalize individual ownership of land because it was not part of our culture. All land shall be owned communally. Now, with reference to Kenya's contemporary legal frameworks, I want us to discuss two things. We are going to discuss the place of cultural justification in informing lawmaking in Kenya. And number two, we are also going to, look at criminalization and discriminalization predominantly on culture, and we are going to provide, a coherent framework for the same. So I want us to start with the first one. That is, the place of cultural justification as far as, customary law is concerned in Kenya. Now, the relationship between law and culture has historically been intimate and complex. Culture shapes social norms, values, and institutions, while law regulates conduct. Law resolves disputes and protects rights. In African societies, including Kenya, pre-colonial legal systems were largely rooted in customary norms, regulating marriage, regulating land tenure, regulating inheritance, regulating dispute resolution, and regulating communal order. Colonialism disrupted these indigenous systems and introduced formal Western legal frameworks, some of which criminalize practices previously accepted within African customary systems. Now, the rise of the Cultural Party of Kenya, CPK, whose political platform seeks to reform law along cultural lines, raises an enduring jurisprudential question. Should legality be determined by cultural legitimacy? And this question invites an examination of the place of culture within Kenya's constitutional democracy and whether criminalization or discriminalization can coherently rest exclusively upon cultural foundations. Now, this paper argues that under Kenya's constitutional framework, culture remains an important source of law, an important source of identity, and an important source of social organization. But it is not an absolute determinant of legal validity. Rather, cultural norms operate within constitutional limits defined by human rights, defined by equality, defined by dignity, defined by public policy, and also defined by social justice. So I want us to look at the place of cultural justification in informing lawmaking. And the first thing I want us to focus on is constitutional recognition of culture. Now, the Constitution of Kenya expressly recognizes culture as foundational to the nation. Article 11 declares culture to be the foundation of the nation and civilization of the Kenyan people, and obligates the state to promote all forms of cultural expression and heritage. Article 44 further guarantees that every person has the right to participate in the cultural life of their choice. If you look at the Endose case, which was decided by the African Commission on Human Rights and People's Rights, this case is foundational to Kenya's potential question, regarding the right to culture and also the right to land. The Endorese community was displaced from their ancestral lands at Lake Bogoria. Now, the commission ruled that the Kenyan government violated their right to culture by preventing them from accessing ancestral sites and practicing their traditional religion. Now, this case solidified that culture is tied to territory and identity, and that the 2010 Constitution now protects these indigenous rights. This constitutional recognition reflects the theory of legal pluralism, which accepts that multiple normative systems coexist within society. Eugene Ehrlich argued that the living law of society often exists outside formal legislation, within social practices and communal relationships. This observation is particularly relevant in Kenya, where customary systems continue to regulate family relations, continue to regulate inheritance, and also community obligations. Thus, Parliament may legitimately draw from cultural practices when formulating law. However, cultural legitimacy alone is insufficient to confer legal validity. Now, let's look at constitutional supremacy as a limitation on culture. Now, the Constitution establishes itself as the supreme law of the Republic. Article 2 provides that any law, including customary law, that is inconsistent with the Constitution, is void to the extent of the inconsistency. This means that culture cannot override constitutional rights or constitutional principles. This principle was affirmed by the Kenyan Court of Appeal in Mary Rono versus Jane Rono and another in 2005, where the court rejected discriminatory customary inheritance practices and affirmed equality in succession rights. The court recognized that while customary law remains relevant, it cannot survive where it conflicts with constitutional or statutory equality principles. And this demonstrates that culture informs lawmaking, but cannot determine it absolutely. Now let's look at culture and human rights standards. Now the Bill of Rights imposes substantive limitations on cultural practices. Article 27 guarantees equality and freedom from discrimination. Article 28 protects human dignity. Article 53 protects children from harmful and cultural practices which are harmful. Now, this constitutional architecture, makes it clear that culture cannot justify practices that undermine dignity, that undermine equality, or that undermine welfare. The South African Constitutional Court in B and others versus Haye Tilsha Magistrate and others, Haletisha invalidated customary inheritance rules that excluded women from succession, holding that constitutional equality overrides discriminatory custom. Though not binding in Kenya, the decision is persuasive in demonstrating the constitutional subordination of custom. Similarly, the Kenyan law cannot accommodate cultural practices that violate constitutional rights. In the case of Republic versus Richard Lebriparo 2011, the High Court acknowledged that while the Constitution promotes the use of traditional dispute resolution, there is a clear hierarchy. So that in serious criminal matters, specifically murder, the state has an overriding interest in protecting the right of life according to Article 26. Now, the judge noted that murder is an offense against the state, not just a private matter between families. And number two, that allowing blood money to replace a criminal trial could lead to a system where the wealthy can buy their way out of murder, which violates the principle of equality before the law, according to Article 27 of the Constitution. And thirdly, the judge noted that cultural practices must be consistent with the Bill of Rights. Now, the court in this case refused to terminate the murder charges. It held that while the cultural settlement could be considered a mitigating factor during sentencing if the accused were found guilty, It could not serve as a substitute for a criminal trial or a reason, to discharge the accused. Now let's look at the harm principle in criminalization. Now, John Stuart Mill argued that criminal law should prohibit conduct only where it causes harm to others. Now, this principle is relevant in determining whether cultural practices should be criminalized or decriminalized. For example, traditional brews may fall within personal autonomy and cultural expression, while child marriage directly harms children through denial of education, through health risks, and also through compromised autonomy. Thus, the critical inquiry that is not whether a practice is cultural, but whether it causes social harm. So that culture is evidential and not determinative. The case of Republic versus Brown of 1993 is the foundational case for discussing the limits of the harm principle regarding consensual acts. And the facts of this particular case were that a group of men engaged in consensual, private, sadomasochistic acts. They were charged with assault occasioning actual bodily harm and unlawful wounding. And the argument was that the defendants argued that because the acts were consensual and private, no harm in the million sense was done to society or non-consenting parties. And the ruling of this particular case was that the House of Lords upheld the conviction. And the principle is that the court ruled that consent is not a defense to the infliction of ABH or more serious injury unless it falls under recognized categories like sports, like surgery, or tattooing. The court prioritized public policy and morality over the harm principle, fearing that such behavior might corrupt others or lead to escalating violence. Now, let's look at international law obligations. You see, Kenya's constitution incorporates international law into domestic law under Articles 2.5 and 2.6 of the Constitution. And this includes, treaty obligations that affect legislative policy. Kenya is a party to the United Nations Convention on the Rights of a Child, the Convention on the Elimination of All Forms of Discrimination Against Women, and the African Union African Charter on the Rights and Welfare of the Child. These instruments prohibit harmful practices such as child marriage and gender discrimination. Accordingly, Parliament cannot enact legislation that legitimizes harmful cultural practices contrary to international obligations. The case of Dr. Tatu Kamau versus Attorney General and others in 2021 is the most direct authority regarding Parliament's inability to legitimize a harmful cultural practice, specifically female genital mutilation. And the facts of this particular case were that a doctor challenged the constitutionality of the Prohibition of Female Genital Mutilation Act, arguing that it infringed, on the cultural rights of adult women who consented to the practice. And the argument was that the petitioner argued that Parliament overstepped by criminalizing a cultural practice protected under Article 44 of the Constitution. And the ruling is that the High Court upheld the act. And the principle is that the court held that culture is not absolute. It ruled that Parliament has a constitutional and international obligation to protect citizens from harmful practices. The court cited Kenya's obligation under CEDAW, that is the Convention on the Elimination of All Forms of Discrimination Against Women, and also the Maputo Protocol, which, mandate the state to prohibit harmful traditional practices. Now, the conclusion of this particular case was that Parliament acted correctly and was indeed required to enact legislation that suppresses harmful culture in favor of international human rights. Now, let's look at democratic legitimacy versus constitutional morality. Now, winning political power does not create authority to enact an unconstitutional law. Constitutional democracy differs fundamentally from majoritarian populism. In the case of Joya and six others versus Attorney General and three others, 2004, the High Court led by Justice Ringera made a revolutionary distinction. And the first distinction was amendment versus replacement. The court held that Parliament's power under Section 47 was limited to amending specific parts of the Constitution. It did not have the power to replace the entire document. Also, the court also made a distinction, concerning, the people's sovereignty. The court ruled that the constituent power belongs to the people because a constitution is the foundation of the nation. Its replacement, requires the direct participation of the citizens. The court also ruled on the mandatory referendum. The court held that any process that leads to a new constitution must involve a referendum, as this is the only way for the people to exercise their constituent power. Now, the conclusion of this particular case was that the court declared certain sections of the Review Act unconstitutional. Now, this ruling effectively stopped the Bomas draft from being enacted directly by Parliament and forced, the 2005 referendum and eventually the 2010 Constitution. Now, what is the connection now to culture and international law? While the Njoya case was primarily about the process of lawmaking, its impact on culture and international law is profound. The first impact is culture as a foundation. The judgment emphasized that a constitution is not just a legal document, but a reflection of a people's history, values, and culture. And this paved the way for Article 11 of the 2010 Constitution, which explicitly recognizes culture as the foundation of the nation. Now, on the international human rights, the court used, international standards of participatory democracy to justify why a referendum was necessary. It signaled that Kenya's internal legal changes must align with global norms of democratic legitimacy, so that culture may influence democratic choices, but constitutional morality remains supreme. So the conclusion is that Kenya's legal framework recognizes culture as an important source of law, an important source of identity, and also an important source of social organization. However, culture is constitutionally limited by rights, limited by equality, limited by dignity, limited by children's welfare, and also limited by international obligations. So that culture may inform lawmaking, but it cannot legitimize injustice. Now, I want us to focus on the second issue, that is whether criminalization or discriminalization predominantly on cultural basis provides a coherent framework. And this is an advice to the CPK party. Now, criminalization or discriminalization based predominantly on culture does not provide a coherent legal framework. This is because culture is dynamic, culture is diverse, and at times culture can also be oppressive. So that law must instead be grounded in objective principles, and I'm talking about principles such as harm, principles such as justice, principles such as right protection, and also principles such as public welfare. So that a practice is not just merely a practice because it is ancient. As H.L.L. Hart argued, that law is a social fact, but that its application requires rational consistency, rational justification, and institutional legitimacy. If you look at the case of Muruatetu versus Republic of 2017, this case challenged the irrationality of mandatory sentencing. And the facts of this particular case was that the petitioner challenged the mandatory death sentence for murder. And the legal argument was that the law as it stood removed, rational justification of judicial discretion, so that it treated all offenders the same. regardless of the specific facts of the case. And the ruling in this particular case was that the Supreme Court held that a mandatory sentence is unconstitutional because it is arbitrary. So here is the Haitian link to this particular case. This case, aligns with Hart's idea that for a legal system to be functional and legitimate, its rule must be applied in a way that allows for rational adjudication, so that the court restored, the secondary rule of adjudication by giving judges the power to determine sentences based on logic and evidence. If you look at the case of Muzi Mbamuto versus Bach of 1968, this case is a classic Commonwealth case often used to teach Hart's theory of legal validity during a revolution or a break in the legal system. Now, the facts of this particular case were that following the unilateral declaration of independence in Rhodesia, now Zimbabwe, the rebel government detained Mazimbamoto. He challenged the detention, arguing the new government was illegal. And the issue was, when does a new rule of recognition become legitimate? And the analysis of this particular case was that the Privy Council had to decide if the new regime's law were valid. Now, Hart's theory suggests that a rule is valid if it is accepted by the officials within the system. However, the court ruled that since the UK still claimed sovereignty, the rebel regime lacked institutional legitimacy. And the conclusion of this particular case was that this case highlights, Hart's point that law depends on a socially acceptable rule of recognition. So that without it, the law is just, some sort of naked power. Now, I want us to look at traditional brews. Here, we have partial discriminalization with regulation. Now, the CPK proposes, discriminalization of traditional brews on grounds of cultural legitimacy. Now, traditional brews such as Pusa, such as Chang'an, have long existed within Kenyan communities and carry, cultural and economic significance. However, their regulation falls under the Alcoholic Drinks Control Act in Kenya. So that the legal issue is not whether they are cultural, but whether they present public harm through unsafe production, through poisoning, and also through addiction. So that applying Mill's harm principle, the proper legal approach is regulation rather than absolute prohibition or unrestricted legality. So the CPK should therefore pursue legislative reform aimed at licensing traditional brewers, regulating, safety standard, and also protecting the health of the public. You see, this approach balances cultural recognition with public safety. The other issue raised by the CPK was the cannabis, that is banned, which is also they can come up with a controlled sort of medicinal reform. Now, the proposal to decriminalize cannabis purely because it is cultural lacks, a strong legal and sociological grounding. You see, cannabis remains criminalized under the Narcotic Drugs and Psychotropic Substances Control Act. Now, the basis of criminalization is primarily public health and international drug policy and not cultural suppression. If you look at the case of Minister of Justice and Constitutional Development and others versus Prince 2018, the South African court effectively decriminalized the private use, possession, and cultivation of cannabis by adults for personal consumption. And the court, in a unanimous judgment delivered by Deputy Chief Justice Raymond Zondo, reasoned that number one, the right to privacy is not confined to the home. It protects the inner sanctum of a person's life. Number two, that the state failed to provide sufficient evidence that the use of cannabis by an adult caused such significant harm to the user or society that it warranted the invasive measure of criminalization. Thirdly, the court noted that alcohol and tobacco substances proven to be harmful were legal and regulated, making the absolute ban on private cannabis use to be disproportionate. Fourthly, the court declared the relevant sections of the act unconstitutional and invalid to the extent that they prohibited the private use, possession, or cultivation of cannabis by an adult for personal consumption. Now, the court suspended the declaration of invalidity for 24 months to allow Parliament to amend the law, but granted, interim relief so that adults could not be arrested for private use in the meantime. Now, the CPK should therefore advocate for medicinal cannabis legalization. They should advocate for scientific review, and they should also advocate for tightly regulated private use reforms rather than, a blanket kind of discriminalization. So that the law reform must be evidence based. Another thing that the CPK raised was the issue of child marriage, and here we have to maintain, criminalization. Now, the CPK proposes, discriminalizing child marriage because it existed historically in a customary system. Now, this proposal is legally untenable. Article 53 protects children from harmful cultural practices. Article 45(2) recognizes marriage only between consenting adults. The Marriage Act 2014 fixes, 18 years as the minimum age of marriage. The Children Act 2022 reinforces protection against early marriage. So that child marriage violates consent, it violates dignity, it violates health, and it also violates, educational rights. Therefore, culture cannot justify exploitation. The Cultural Party of Kenya should reject this proposal entirely and strengthen, enforcement mechanism against child marriage. Another issue that was raised by the CPK is private land ownership. And here we have to reject, criminalization. You see, the CPK proposes, criminalizing private land ownership on the basis that traditional African societies favored communal land systems. Now, this proposal directly conflicts, with the Constitution. Article 61 recognizes land ownership in three forms: public, community, and private. Article 40 protects, the right to acquire and own property. In Isaac M. Inanga Kibeo versus Isaiah Theuru and another, 2015, the Supreme Court recognized customary land rights while preserving constitutional land order. And you see, this demonstrates, the coexistence rather than the exclusivity. Now, the appropriate reform is not abolition of private ownership, but stronger land redistribution mechanism, anti-land grabbing enforcement, and also protection of community land rights. So why does culture alone fail as a legal reform framework? You see, culture is not uniform. Kenya has over 40 ethnic communities with different customs and traditions. So that if law is based predominantly on culture, then the question arises, whose culture becomes law? So that majoritarian cultural legislation has a tendency of risking exclusion and also risking marginalization. Another thing is because culture evolves. You see, many practices once culturally accepted are now recognized as unjust. And examples, include female genital mutilation. Another example is wife inheritance. And also a good example is child betrothal. Hence, historical acceptance cannot justify present injustice. Now, another issue is cultural law, requires principled justification. You see, criminalization must rest on demonstrable kind of harm. It must, rest on public order, and it also has to rest on rights protection. As Roscoe Pound argued, law must balance, competing social interests. Law cannot rest on nostalgia alone. Now, development also requires legal certainty. Economic development depends upon predictable and stable legal systems so that land ownership, family law, and criminal justice, they all require certainty. Purely cultural law reform is going to create, some sort of instability in the country. So the conclusion is that culture remains a vital source of legal identity and legitimacy in Kenya. The Constitution recognizes and protects cultural diversity. However, culture remains subordinate to constitutional rights, to equality, to dignity, and public welfare. Now, the Cultural Party of Kenya should adopt a principal reform model by regulating traditional brews, cautionary, reforming cannabis laws through scientific evidence, maintaining criminalization of child marriage, and preserving private land ownership while strengthening community land protection. So that a sound legal system does not merely ask whether a practice is old, it asks, whether a practice is just. So that is all I have as far as these two issues are concerned. If it is your first time here, make sure to follow this channel and to subscribe for more legal lessons.